First, let's refresh our memories. Zen Gardens asked to file a supplemental brief to make sure that their argument was included about what they were saying on why they were contesting the summary judgment and other things. And I'll just refresh your memory. I won't do the whole brief again. I'll put a link in the description box if you would like to see the full document of what Zen Garden's argument was on why they should file the supplemental brief. But here is just enough to get us on the same page because the court has come back with a decision based on Zen Garden's request. Please also just watch the other Zen Gardens videos to get caught up. There is a lot of information and I'm not going to be able to go through all of it in this video. So the main part of Zen Garden's argument as to why they wanted to add a supplemental brief to their original argument is that when on October 2nd, 2023, Zen Gardens submitted its opposition to Scholt's motion. In its brief, Zen Gardens addressed Scholt's argument above and conceded that to the extent its negligence and other counterclaims were premised on a contractual duty, it could not recover that against Scholt. However, in that concession, Zen Gardens did not cede or give in that Alabama law generally imposed no duty care on Scholt as a builder. So although Zen Gardens apparently may have felt they did not have a strong argument for negligence, they never conceded that that also meant that the Alabama law did not protect them. This is future trending here. I want to correct myself. I meant to say that Zen Gardens is still arguing negligence, but they are citing an Alabama law in their supplemental brief. So I apologize for that confusion. So it says absent two was any concession that Scholt's failures were limited to a failure to perform just solely based on a contractual obligation, i.e. general nonfeasance. Through sheer unintentional omission, the undersigned neglected to include further argument on Scholt's contentions in his opposition. Counsel only just realized this omission. On February 2nd, 2024, the court did issue an order in response to Zen Gardens' motion to file their supplement brief. In that order is stated, this action is before the court on the motion of defendant Zen Gardens LLC for leave to file a supplemental brief, document number 44. Upon consideration, the motion is granted. Defendant is directed to file the brief no later than February 7th, 2024, done and ordered the second day of February 2024. So the court has allowed them to enter that argument into their opposition brief, that they are allowed to also argue that Scholt did not operate properly under Alabama law when it came to no duty care. So that is in, and therefore, since the court had not ruled on anything yet, that will be considered because on February 6th, and they had until February 7th, Attorney Rogers, I call him Mr. Rogers because I think about the show, Attorney Rogers filed the brief. So it has a new filing date for February 6th to show that they filed it before their deadline of February 7th. And so that argument will be in court along with everything else. And I will keep you updated. Talk to you later. Bye.